Leaves granted.
Okay, thank the chamber. Is effectively relating to the criminalisation of reporting of national security issues. We'll do this in two tranches, and I'll speak at more length on the first. There's a later batch of amendments that relate to similar matters, and I'll just reserve my comments on both of those now. These ones relate specifically to reporting of SIOs, even their mere existence. Schedule 3 creates new offences relating to disclosing information on special intelligence operations, or SIOs, with a period of penalty of 5 years imprisonment. And Schedule 6 creates new offence provisions and updates existing offences relating to the unauthorised disclosure of intelligence-related information, and we come to those a little bit later in the debate. Now, what's effectively happening here is that under the proposed subsection 35p1, a person will commit an offence if he or she discloses information and the information relates to a special intelligence operation. The maximum penalty, as I've said, would be imprisonment for up to 5 years. And these offences are by far the most controversial aspect of the proposed scheme, and I would argue of the proposed legislation. So two major concerns have been raised: that the offences do not contain exceptions for public interest disclosures, which I think Senator Xenophon will try and address in a forthcoming amendment, or whistleblowing by ASIO employees, and they apply to any person and would thereby capture disclosures by, for example, journalists. And many submitters made that point to the PJCIS. This is something, and I'd go back to earlier stages of the debate yesterday where we were discussing the document that the Scrutiny of Bills Committee had prepared when evaluating this bill, and they'd identified 19 areas over which they had grave concerns. One of them was this very issue, subsection 35p. The committee sought a fuller justification from the attorney as to why penalty of imprisonment for 5 years is considered appropriate, given the breadth of application of the offence provision. Now, what this actually means in practice, which was stated very bluntly by a number of the submitters, and the first contribution that I'd like to read is one that was made, submission number 17, by combined media organisations. So parties, this quote that I'm about to read was signed by the following: AAP, ABC, APN, Astra, Bauer Media, Commercial Radio Australia, Fairfax Media, Free TV, the MEAA, News Corp Australia, SBS and the West Australian, under a section of their submission which they've titled Jailing Journalists for Doing Their Jobs. They say the following: the insertion of proposed section 35p could potentially see journalists jailed for undertaking and discharging their legitimate role in a modern democratic society, reporting in the public interest. Such an approach is untenable and must not be included in the legislation. Well, I can say to our colleagues in the press gallery tonight that it is included in the legislation, and that we may be about to legislate away your extremely important role in our democracy. They go on to say that this alone is more than adequate reason to abandon the proposal, as the proposed provision significantly curtails freedom of speech and reporting in the public interest. This is particularly so as the proposed section 35p prohibits any disclosure of information relating to an SIO, not just reporting in the public interest. It's a blanket prohibition. Now, the trick is, how would you know if you had done that? Because the very existence of SIOs will be suppressed. So these entities, which make up by far, I think, the largest fraction of those working up in the parliamentary press gallery, not sure where they all are tonight, but nonetheless, their submission speaks for itself. They go on to say, in addition, SIOs by their very nature will be undisclosed. This uncertainty will expose journalists to an unacceptable level of risk and consequentially have a chilling effect on the reportage of all intelligence and national security material. A journalist or editor will simply have no way of knowing whether the matter that they are reporting may or may not be related to an SIO. We express this as information that may or may not be related to an SIO because it may or may not be known if the information is related to intelligence operations and whether or not that intelligence operation is an SIO. Relates to is not defined, and therefore the breadth of relevance is unknowable. It is unclear whether SIO status can be conferred on an operation retrospectively, i.e. if information has been disclosed, whether any operation that may be associated with or related to can retrospectively be allocated SIO status. And finally, it is likely that clarity about any of these aspects would only come to light after information is disclosed, particularly in the case of reporting in the public interest. This is damning. This submission is damning. I cannot for the life of me understand why the opposition is lining up in supporting this uncritically. Perhaps Senator Collins can inform us. But I'd like Senator Brandis to tell us how those in this press gallery and working journalists around the country will know in advance whether what they are deciding to report in tomorrow's paper may or may not be related to an SIO. How will they know without simply publishing and hoping for the best?
Senator Brandis.
Thanks, Mr Acting Chairman. The Greens seek to remove from the bill the offence in section 35 capital P1, which applies to persons who intentionally communicate information reckless as to the circumstances that it relates to a special intelligence operation. The government does not support this amendment. It is inconsistent with the unanimous view of the PJCIS. As the PJCIS in its report recognised, the offence provision is necessary and appropriate to protect sensitive information about the existence and conduct of covert intelligence operations. The very disclosure of the existence of such covert operations creates a risk that they may be compromised and that the safety of their participants and their families might be placed in jeopardy. Such a risk could be immediate or could arise over the longer term. There is no way of controlling it once it is disclosed. This risk of harm, potentially harm to life, is inherent in the disclosure of such information. It does not depend in any way on the discloser's intention. As Justice Hope observed in his 1984 report on ASIO, if I may quote him, "The disclosure of secrets or secure areas to risk through inadvertence or carelessness can result in just as much damage to the national interest as can result from espionage or sabotage." But here, unlike the observation Justice Hope made all those years ago, we have a higher threshold, that is, intention to disclose with reckless disregard of the circumstances. The Australian Law Reform Commission has also endorsed the view that offences concerning unauthorised disclosure of intelligence-related information should not be limited to those which require proof of harm or malicious intent. That is because such harm is inherent in the very act of disclosure, which places the information at risk. As the PJCIS further recognised, the offence requires the prosecution to prove that the person who disclosed the information was reckless as to the fact that it related to a special intelligence operation. And of course, Senator, it perhaps should go without saying, but let me remind you that this being a criminal offence, the burden of proof lies on the prosecution to prove every element beyond reasonable doubt. As the PJCIS acknowledged, this is an onerous burden of proof. The prosecution must establish to that standard of proof that the person knew of a substantial risk that the information resulted to a special intelligence operation. It must then establish that the person nonetheless and unjustifiably in the circumstances took the risk of making the disclosure. Now, Senator Ludlam, might I also point out to you that although you claim in an exuberance of rhetoric that this is a new and an extremely dangerous provision, it is entirely of a piece with a number of existing provisions in the law. In particular, the offence elements are identical with the existing provisions of section 15HJ of the Crimes Act, which creates the same offence in relation to the disclosure of controlled operations by the Australian Federal Police. That provision was inserted by the previous government in 2010. In fact, there have been no prosecutions or referrals for prosecution to date, so that should tell you that this is a provision that would be very sparingly used. It should also give you a level of reassurance, Senator, I hope. It strongly suggests that the offences are not operating to unduly curtail media reporting of or public disclosure in relation to security matters. And you do, if I may say so, Senator Ludlam, though you often do this, raise a false fear. This is not about reporting on the operation of the intelligence agencies. It is about intentionally disclosing a covert operation with reckless disregard as to that circumstance. And in circumstances where, because of the very nature of a covert operation, the persons involved in that covert operation are likely to be placed at risk of harm or indeed at risk of their lives. Lastly, Senator Ludlam, you did say in your contribution that you were concerned that this would constrain the rights or eliminate the rights of whistleblowers. That also, Senator Ludlam, like so many things you said, is erroneous. The existing protections of whistleblowers under the ASIO Act are preserved and are unaffected by this amendment.
Senator Collins.
Thank you, Chair. Senator Ludlam addressed at least part of his question to the opposition, so I'll supplement Senator Brandis's comments with the point that the Joint Parliamentary Committee probably spent almost the most time on any of the issues addressing this particular matter, and the opposition remains confident with the outcome and the recommendations arising from that, which are reflected in the government amendment that makes clear that the offence only operates where a person is aware of a substantial risk, that information relates to an SIO, and it is unjustifiable to take that risk. So once again, Senator Ludlam, we would be relying on the consideration of the Joint Parliamentary Committee.
Senator Xenophon.
Thank you, Mr Acting Chair. Can I indicate my support for this amendment for these reasons? This amendment does not touch clause 35p, subclause 2, which relates to committing an offence if you disclose information relating to a special intelligence operation and it could in any way endanger the health or safety of any person or prejudice the effective conduct of a special intelligence operation. So not just about health and safety of our intelligence officers, which ought to be a very key and important consideration. That is why I supported Senator Lazarus's amendment to increase substantially the penalty in respect of that. But this amendment seeks to delete the offence of up to 5 years imprisonment of simply disclosing a special intelligence operation. It must be read in conjunction with subclause 2, which ought to remain subject, I hope, to an amendment that I'll be moving in respect of public interest considerations. So that is the difference. If you disclose information and that information prejudices an operation, prejudices the health or safety of intelligence officers, that will still be an offence, and the Australian Greens aren't seeking to get rid of that. I think we need to listen to the Fourth Estate in relation to this. I think we need to listen to organisations such as diverse as Fairfax Media, AAP, SBS, the Commercial Radio Australia, the West Australian, the ABC, Free TV and News Corp in relation to their concerns. They have set out very clearly and unambiguously the insertion of proposed Section 35p could potentially see journalists jailed for undertaking and discharging their legitimate role in a modern democratic society, reporting in the public interest. Such an approach is untenable and must be not included in the legislation. And I'm conscious of time, and I'll be as quick as I can, but I do want to make mention to what occurred almost 30 years ago. Almost 30 years ago, Peter Wright, a counterintelligence officer from Britain's MI5, which is the UK's counterpart to ASIO, wrote a book, Spycatcher. The British government, in particular the British Attorney-General, Sir Michael Havers, in consultation with the Director of Public Prosecutions, decided to prosecute Wright for unauthorised disclosure of classified information. Heinemann, the UK publishing house, tried to avoid an injunction preventing publication by transferring the book to their Australian subsidiary. The British government decided to take legal action in Australia and in the United Kingdom. Accordingly, in September 1985, the British Attorney-General began proceedings in Australia against Peter Wright and the publisher, Heinemann Australia, seeking an injunction to prevent publication on the grounds that Wright was in breach of his duty of confidentiality to the Crown. The Attorney-General admitted, for the purposes of those proceedings only, that all the allegations in Spycatcher were correct. The admission that Sir Roger Hollis, a former MI5 Director-General, had been a Soviet spy was of considerable public interest in Australia, since Hollis had had a major role in the foundation of ASIO. The Spycatcher trial lasted 5 weeks, and Peter Wright's counsel was a young, some would say brash, then 32-year-old lawyer named Malcolm Turnbull. On that occasion, Malcolm Turnbull was able to, on that historic occasion, Malcolm Turnbull was able to make fun, and rightly so, of the exaggerated levels of British secrecy. The Australian Cabinet Secretary Michael Codd, in evidence at the trial, claimed that if Spycatcher were to be published in Australia, the intelligence agencies of Britain and other friendly countries would be unwilling to exchange secret intelligence with Australia. But Spycatcher was published, and the sky didn't fall in. The intelligence agencies of Britain and other friendly countries are quite happy to exchange secret intelligence with Australia. Under this bill, my fear is that with this particular provision, the subject of so much concern by the media, the fourth estate in this country, Spycatcher could not be published in Australia. That is a situation we must not permit. This is where the bill is weak. It assumes a best-case scenario and impeccable behaviour by all concerned, but I've referred to the Witness K case in relation to East Timor, a different set of circumstances, but the principles are the same, Mr Acting Chair. Yet the foundation of Western political thought, as the Attorney-General knows full well, and I say that as a compliment, is that we do not rely solely on individuals to be good or on rulers to be righteous, but on institutions to provide checks and balances. This has been known since at least the second half of the 18th century, when Montesquieu, a French political philosopher, championed the need to resist tyranny by fragmenting government power, particularly through the device of the separation of powers. I have real concerns about the impact of this particular amendment, this particular piece of the legislation on the freedom of the press.
Thank you, Senator Xenophon. The question is the Australian Greens amendments. Senator Ludlam.
Thank you, Chair. I might just, on behalf of those who I cited before and Xenophon just cited, who put that submission, they raised the question about whether SIOs can be declared retrospectively. I don't think it's something that we've canvassed in the debate thus far. Senator Brandis, I wonder whether you could just clarify whether that's possible under the operation of the Act.
No.
Senator Ludlam.
Thank Senator Brandis for the clarity of his answer. It's actually quite bracing. I would also put to you, and the concerns that I shared before would apply, for example, and the submission that the MEAA put to the Joint Committee, submission number 6, raised a very interesting case study, and that being the phone tapping of the wife of Indonesian President Susilo Bambang Yudhoyono, which was controversial reporting, I would argue public interest reporting, and it was obviously based on disclosure of operations that took place well before the SIO scheme came into place. Senator Brandis, had that wiretapping been done under the framework of an SIO, which I think is entirely plausible, would that reporting have been illegal?
Senator Brandis.
Well, Mr Acting Chairman, I'm not going to indulge Senator Ludlam by answering hypothetical cases or cases of historical interest, or indeed addressing cases or issues that may come before the courts. The legislation is before you, Senator. You've made your position clear. You're entitled to the view that you take, and really that's all I have to say to you.
The question, Senator Ludlam.
Thanks, Chair. I'll just go to the. It's rather extraordinary because that's not a hypothetical case. I'll put another one to you. The Guardian in submission 12, who do a lot of national security reporting, as you'd be well aware, they note in their submission on page 8 of the 20 public reports of the Inspector-General of Intelligence of Security, that's as at 31 July of this year, 9 appear to have been triggered directly or indirectly by media disclosures. The unfortunate case of Dr Mohammed Hanif was largely brought to life by the media. That's a case that has well and truly run its course. It's not something that is going to be brought before the courts. I wonder, Attorney, whether you could outline for us whether reporting of that case strongly, clearly and unambiguously in the public interest would have fallen foul, whether reporting would have been illegal if an SIO had been in place at the time of those events?
Thank you. The question is that Australian Greens amendments. Senator Ludlam.
Thanks, Chair. It's unacceptable that the Minister has just returned to an earlier, rather childish pattern of behaviour of simply refusing to answer simple questions put in the committee stage. It's absolutely extraordinary of a bill of this gravity, and thank you for at least acknowledging that I'm entitled to have these views, and so are the many, many people, including the working journalists of this country who've put these questions before you. They don't get the opportunity to ask questions in the committee stage. That's my job, and I would appreciate at least the courtesy of response to direct and relevant questions that I'm putting to you. That's what this stage of debate is for. The Human Rights Commission noted this, as many others did, not just journalists and their representatives. The Human Rights Commission, in their submission number 28 on page 14, noted the following. The provisions deal with disclosures from a person. They have the potential to capture the work of journalists and potentially limit the right to freedom of expression under Article 19 of the ICCPR. The HRC has stated that the media plays a crucial role in informing the public about acts of terrorism, and its capacity to operate should not be unduly restricted. In this regard, journalists should not be penalised for carrying out their legitimate activities. Senator Brandis, how is it that all of these entities who study these issues for a living could possibly have it so wrong? By what means does the government believe that the potential criminalisation of national security reporting makes our country any safer?
The question is that Australian Greens amendments on sheets 3 to 5 on sheet 7570 be agreed to. Those of that opinion say aye. Senator Milne.
Thank you, Mr Chair. I want to rise tonight to support my colleague Senator Ludlam in asking Senator Brandis to answer the questions. This is the committee stage of this important legislation. This is seriously challenging the right of journalists to be able to report in the public interest. It's extraordinary that he is refusing to answer very straightforward questions. Now, of course, we know that the Labor opposition is going to go along with this regardless. They're not even interested in what the answers are. But the Fourth Estate in Australia is interested, and we want to know what exactly the penalties are going to be. Journalists around the world are being jailed for simply reporting the news. We know that in the case of Peter Grester, for example, our own journalist in Egypt, and we have condemned the Egyptian government and the legal system there for the farce that was the trial that sees him continue to languish in prison in Egypt for simply doing his job. Now, we are putting to Senator Brandis here tonight questions that go to the heart of the issues of reporting what is going on. I cannot believe that here on a Thursday night this chamber is virtually empty, and yet we have seen already tonight penalties increase from 1 to 10 years for various things. Incredibly draconian legislation is being passed, and the minister responsible either cannot or will not answer and is smug because the opposition is going along with it. I ask Senator Brandis to answer the questions being put to him in the committee stage of a bill, as is expected of a competent minister. Or is he incompetent and unable to answer the questions being put?
Senator Brandis.
Thank you, Mr Acting Chairman. Senator Milne, there's no need to be discourteous. The reason I didn't respond to Senator Ludlam's question, Senator Milne, is very simple, because I had already answered it. In fact, I'd already answered it twice in the course of this debate, and I am not going to facilitate Senator Ludlam's parliamentary tactic of filibustering this legislation by responding repeatedly to questions that have already been asked and have already been addressed. That is the reason, Senator, why I am not going to respond to questions already asked and already answered. Now, Senator Milne, you mentioned Peter Grester. Senator Milne, this government has gone to enormous lengths on behalf of Mr Peter Grester, whose parents are constituents of mine, and as his family well knows and generously acknowledges. The Prime Minister has engaged the Egyptian head of government. The Foreign Minister has on numerous occasions engaged her Egyptian counterpart and the Egyptian ambassador to Australia. I have engaged at length the Egyptian Attorney General. Don't try and make a cheap political point, Senator Milne, out of the fate of Peter Grester.
The question is that Australian Greens amendments 3 to 5 on sheet 7570 be agreed to. Those of that opinion say aye. Against say no. No. I think the noes have it. Division required. Ring the bells. Lock the doors. The question is that Australian Greens amendments 3 to 5 on sheet 7570 be agreed to. The ayes will pass to the right of the chair, the noes to the left of the chair. I appoint Senator Siewert, teller for the ayes. Senator Fawcett, teller for the noes. I'm with you, Senator Fawcett. Order. There being 12 ayes and 36 noes, the matter is resolved in the